All rise. The Court of Appeals for the State of Kansas is now in session. The Honorable Thomas Malone presiding.
Please be seated. Morning, everyone. Welcome to the August docket of the Kansas Court of Appeals here at the Sedgwick Courthouse. First time we've been here for many years. I am Tom Malone. To my right is Judge Catherine Gardner. To my left is Judge Rachel Pickering. We are the panel for today's cases. I'll call the cases in the order of the published docket, and you can give us your appearance then. I'll make up just a few preliminary remarks, although I know we have frequent flyers here for the most part this morning, but just to remind you, we have read your briefs, so we're familiar with the facts of your case and what the issues are. You might keep that in mind as you make your argument. Each side is given 15 minutes for your argument. The appellant's attorney should let us know in advance if you wish to reserve any of your time for rebuttal. After the hearings this morning, your case will be deemed submitted for decision. And after that, we will take the case under advisement and get a written opinion out to you and your clients just as soon as we possibly can. So with that, I'll go ahead and call the first case. It is from Sedgwick County. It's number 128764. The state of Kansas versus Antonio E. Smith.
May it please the court, Antonio Smith appears through counsel Casper Shire, Kansas appellate defender. Antonio is also with us in the courtroom here today. Could I please have 3 minutes for rebuttal, Your Honor?
That is granted. And who do we have for the state?
May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas, present and ready for argument.
Mr. Shire, whenever you're ready.
Thank you, Your Honor. The threshold question in this case is whether an undercover officer offering sex for sale on North Broadway, part of a sting operation, can still become a person who sells sexual relations. If the answer to that question is no, then the case against Antonio has been a non-starter from the beginning. We maintain the plain language sufficiency argument that Antonio made in the district court. A person cannot become something that they already are. Even viewed in the light most favorable to the state, the evidence here does not support the crime the state charged.
What if you're just pretending to be somebody? Can you still then become a prostitute if you're just pretending in the first place?
The facts of this case are that the intent of this officer was to present herself as somebody out there selling sex. Antonio was ultimately convicted of the attempt to promote the sale of sexual relations. So part of the crime here is that Antonio had to have the specific intent to pull somebody who was not in the business, so to speak, into the business. And when someone is out there presenting themselves as somebody who sells sex, who's complaining about having to crank it out for $30 a pop, that's somebody who's presenting themselves as in the business. And the state has not proven that she could become somebody in the business for the purposes of this prosecution.
Counsel, how are you defining become?
I define it as a change of state. And we provided dictionary definitions. I think both sides provided dictionary definitions in their briefing. And the key language here is not just become, but the statute actually specifies what it is that you have to become. a person who sells sexual relations. So it can't just become somebody who continues to sell sexual relations under different circumstances. That is not the statutory language. The statutory language is become somebody who sells sexual relations. And if you're already out there doing that, you cannot become that.
Do the PIC instructions mirror that as well?
The definition of become,
No, to become a person who sells sexual relations.
I believe so, Your Honor. I have to double check, but I think that's how the jury was instructed, yes.
Does that fly in the face of the public policy arguments for why this statute might have been passed?
I don't know. I haven't given it a lot of thought because the first place we have to look, Your Honor, is the plain language. And the plain language says what it says, which is you have to become a person who sells sexual relations. And frankly, you know, I can think of a reason why the legislature would want to criminalize pulling somebody that's not into the life, as opposed to approaching somebody who's already selling sexual relations and trying to convince them to change their business model. Those are two different things, and I can see a reasonable legislature thinking that the first is worse than the second, and choosing to criminalize the first and not the second.
There's nothing new about this statute, right? It's been around a while.
Yeah, I don't know precisely how long it's been around, but no, I don't think this is a new provision, Your Honor.
Yet there's very little Kansas case law interpreting this particular situation, correct?
That is true, and the district court, and I think the parties as well, all acknowledge that. I wasn't able to find any. I think based on my my opponent's briefing, he wasn't able to find any either. So I think we are here in this court to tell us what it means to become somebody who sells sexual relations. Does that require a change in state?
Have we looked at what other states have said on that similar issue?
I have not, Your Honor. I would just go back to our Supreme Court, our Kansas Supreme Court's expressed preference for looking at and applying plain statutory language. And that means become a change of state, a person who sells sexual relations. You have to go from somebody who's not to somebody who is.
But that defense was able to be presented at trial or not able to be presented?
It was restricted, Your Honor, and that's the second problem with this case, as we've raised it in issue 2. The district court did consider a motion to dismiss on this issue, ruled against Antonio. That was renewed with a directed verdict motion at the close of the state's case, as is very common in virtually every trial. And then when Antonio's attorney tried to present this defense to the jury, he got cut off by state objection. And he was effectively told that the court read a special instruction, which I found confusing. And Antonio's attorney had to move on to the second defense, which is that, you know, none of this was serious anyway, right? He didn't get a full and fair opportunity to litigate this particular issue to the jury. The district court expressed a belief that, hey, this is a legal question. I've ruled on the legal question. That's settled. The jurors are just there to find the facts. And that is, in our view, a fundamental misunderstanding of the jury's role in this situation. Jurors are where the rubber meets the road. They are the ones who apply the facts as they find them to the law. Just because you've made a sufficiency argument and it's not successful does not mean that you cannot present exactly the same defense to the jury. In fact, that is routinely what defense attorneys do. as a class of people, I don't think I'm revealing any, deeply held secrets of the defense bar in saying we generally attack the state's case where we believe it's weakest. So the same place we're making a sufficiency argument is the same place we're going to take the case to the jury. And when you restrict an attorney's ability to do that, you are denying the ability to present a complete defense and denying Antonio a fair trial.
If we agree with you on the first issue of insufficient evidence, does that moot all the rest of your arguments?
Yes. The final thing that I'll try to hit before I close at least the opening portion of my remarks is the prosecutorial error argument, the argument that asked jurors to infer that because Antonio was volunteering his time as a youth basketball coach, that he was using that fifth grade girls basketball team as a feeder program for a sex enterprise. That was wholly unsupported by the evidence. It denied Antonio a fair trial. Nobody is going to get a fair trial where the state is throwing around ungrounded accusations of child sex trafficking.
But there was an objection at trial when he stated, was there?
There was no objection, but it was closing argument, so it is reserved for this court's review.
Sure, I understand it's preserved, but does that show you the weight of the prejudice if there's no objection by the defense counsel?
I think the current case law on that is that's a factor perhaps this court can look at. But the toxic nature of this kind of accusation, this is essentially 6455 evidence of the worst kind coming in by a closing argument. And all of the issues, all of the baggage attached to 6455 evidence come along with this. It's propensity for one, because I mean, jurors believe that attorneys know more about these cases than they do. And they believe that correctly. We do know more about these cases than we do. So when you have a prosecutor coming in, maybe you haven't heard, he accused Antonio of doing this in his cross-examination. That is not evidence, and Antonio denied it. Then he gets up again and says, you should infer that that's what's happening. That is propensity evidence against Antonio. That is very damaging to his credibility in a case where credibility was very important, where Antonio testified about what the nature of his conversation with this undercover officer was and how he meant it as a joke. And it's also brings up this factor that this jury is going to punish Antonio for something that the state is suggesting that he's done to children rather than because they've met their burden of proof in this case. So for all of those reasons, it cannot be harmless.
Does it suggest evidence that's not by that state? His enterprise could be prostitution involving the basketball.
There was nothing involving the basketball team in the record besides Antonio offering for the jury as part of his testimony. When you're accused of being a pimp, you need to tell the jury how you actually spend your time, and he did. There's no evidence that he was using his status as a youth basketball coach to do anything inappropriate.
Right, you used 12 minutes.
And I think I've touched the things that I hope to touch on. So unless there are further questions at this point, I'll save my remaining thoughts for rebuttal. Thank you, Your Honor.
May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas. I will confine my remarks this morning to the first three issues as well, unless this court directs me otherwise. Regarding the first issue, what I've heard argued today is that this court should rely on the plain language. What I do not hear the defendant saying that there is any ambiguity in that plain language. In fact, the parties all agree on the definition that should be applied here. The defendant simply wants to ignore half of it. The definition that both parties cited in their briefs came from Merriam-Webster's dictionary, and that become means to come into existence, to come to be, or to undergo change or development. So while the defendant's argument is one form of how someone could become someone that's selling sexual relations, the state asserts and maintains that he is ignoring the undergoing a change or development, because that is exactly what the defendant in this case did. He attempted to recruit an undercover officer to come and work for him as a pimp. She wasn't getting enough money, in his opinion. He couldn't get her to make more, that she would then sell herself and he would profit from that.
Is that in the statute though? If the statute reads inducing another who's 18 years of age or older to become a person who sells sexual relations, not to become a person who's gonna make a lot more money selling sexual relations. Are you putting words into that statute?
No, Your Honor, the state is not putting words into that statute because you have to understand the meaning of become. To become someone that sells sexual relations, it can mean, as the defendant claims, to do it, to initiate, to induce someone to initiate their selling of sexual relations. But that ignores the additional meaning of become that we all agreed on, and that is that become also includes to undergo a change or development. An analogy that I feel is apt, in addition to the NBA analogy that was argued here.
Sure, so help me out, what is the change or development that was presented for the jury's consideration?
It's, as I explained, the officer was complained to the defendant about the rates she was able to receive here in Wichita. Hypothetically, she was pretending, obviously. And the defendant said that she told her that she could get a lot more money working for him, that he worked girls in Kansas, in the Kansas City area. He managed them, that he would offer her protection, things of that sort. Basically, instead of working.
Refresh my memory, and was the jury given an instruction on what he just defined as to become?
No.
So how would they have known to resolve this case?
Because the plain language, the state maintains that the plain language is clear. To make people understand what become means. Another easy hypothetical that I could make here today, Your Honors, is if opposing counsel and I decided to change offices, if I were to apply to his office, he were to apply to mine, we would switch places. I would become an assistant appellate defender, he would become an assistant district attorney. Everyone can understand that. It is genuinely that simple. The argument that was made today that the legislature would prefer to criminalize just inducing an initiation of selling sexual relations as opposed to forcing or inducing someone to change their circumstances and become beholden to someone else, candidly makes absolutely no sense. And if there were any ambiguity here, the defendant at no point has pressed back against the state's policy arguments that it set forth in its brief regarding the canons of instruction and in par materia analysis. This is a broad sweeping statute to protect individuals from becoming either people that sell sex or people that sell sex under different circumstances, including that where they may be beholden to a pimp.
Okay, so help me out. I'm still struggling with your argument.
Okay.
Okay. Promoting the sale of sexual relations is knowingly. And so how am I reading that plain language? So you're saying to become means to undergo change.
Correct.
So let's insert those words in the statute, okay? Plain language. Inducing another who's 18 years of age or older to undergo change undergo changes as a person who sells sexual relations. Okay, so I've just put your new definition in the statute. How does that change the argument?
I don't think you've added anything to the statute. You've applied the plain meaning of become.
Right, and how does that fit this situation? To undergo change.
Mhm.
Are you saying change means? How are you defining change then? Because I'm still not following your argument.
I think change is clear. It's contained within become. I mean, what we're talking about is someone, and it's argued in my brief. Yes, one type of becoming someone that sells sexual relations can be someone that is induced to initiate that sale. And that's what the defendant is arguing for here. But that's not what become someone that sells sexual relations means. That's not its exclusive meaning. It can also mean to become someone that's selling sexual relations under different circumstances. And that doesn't require reading anything into the statute. It just requires applying the plain meaning of the word become. Does that help?
No,
No.
I'm struggling with it. I'm struggling with it because I think you're adding words into the statute.
Okay. And I guess my pushback to that would be is the state is certainly not trying to do that. That's not proper statutory interpretation. We're trying to apply the plain meaning. And if what your honor is suggesting is that there may be some ambiguity with the meaning of the word become, that ambiguity is resolved by the remaining arguments in the state's brief by applying the canons of construction.
Well, I'm a little confused here. We have to find some ambiguity to even get to the canons of construction or
Correct.
legislative history, right?
Correct.
And you're saying there's nothing ambiguous about this,
That's correct.
even though I think this is one of these cases where both sides say it's unambiguous, but they can't agree on what it means.
I think both sides agree on what it means. I think one side is trying to create ambiguity where there is none. The state is simply trying to apply the plain definition of become straight from Merriam-Webster's dictionary, the same definition that a common reasonable juror would have understood applied under these circumstances. My only suggestion is that in the circumstance where there should, if this court were to agree that there were any ambiguity, then you move to the canons of construction. And in that instance, the state's position is candidly much stronger, even much stronger still, because of the impar materia analysis. In fact, this is part of chapter 64. This is a crime against public morals. It's not a sex crime. It's not a person crime. And then as well as the arguments that I presented in my brief about the surplusage canon and another one that I dare not try to pronounce today in Latin.
I struggle with it as well.
Yeah.
It's always okay. Could it be so simple as this? And you're gonna hate the question. Could it be so simple as this? We're gonna follow the plain language of the statute. And here the person who solicited him was already a prostitute, and therefore he could not induce her to become a prostitute since she already was. So could there be absolutely nothing wrong with the statute whatsoever? That's why it's been on our books for quite some time. Until you come to a case like here, where he's being prosecuted in a way that doesn't match the facts. Is that a possibility?
My answer to that is that it is a possibility, but to bring that possibility to bear would be to abandon this court's duty to apply plain meaning.
Sure.
And the alternative to turn to the canons of instruction. It would be for this court to insert its judgment, your three individuals' judgment about what you think become means, as opposed to its common meaning. And what it's clearly intended to mean as it's set forth in the statutes.
Did you attempt to do any legislative history on this? I don't recall that in the brief.
No, Your Honor, candidly, what we argued was the impar materia analysis, focusing on the fact that it is in the chapter 64 crimes against public morals. It makes sense to be there when this isn't. When we're talking about changing someone's circumstances, we're further undermining their morals. That makes sense for this statute to be there. subjecting them to a change in conditions, a development in their already perhaps distasteful life choices. It makes sense that the legislature would want this there. And for what it's worth, I did note that there were questions about this officer was indeed pretending. And I think both parties perhaps could have pushed that a little bit further in our briefing, but this wasn't someone that was actually selling sexual relations. She was pretending to be. So I think that there may be an argument, there may be something there about the come, but again, we would maintain our focus on the arguments that were made in our brief. Briefly, if I may, on issue 2 about the state maintains that the constitutional argument was not preserved here. And that what happened here is that the district court made a finding as a matter of law that is not the province of a jury. The defendant was still allowed to present an argument that, as a matter of fact, he did not attempt to induce this officer to become someone selling sexual relations. But he was what the parties could not do was try to redefine the law for the jury. That's all that happened.
Did you want to touch upon the switcher misconduct?
Sure.
Here?
I'm going to focus on just the first claim unless this court has questions about the second. But the argument about the defendant, it was a rhetorical question that the prosecutor posed to the jury whether the defendant used a youth basketball program as a feeder program for an alleged prostitution enterprise. The state maintains that to a certain degree, arguments aren't always necessary, but this one, while maybe not necessary, was rooted in the evidence here. We had the text messages from the defendant's phone that were photographed that admitted in evidence. One of them was the defendant texting an individual telling her to bring her daughter with you and we can take you to turn some tricks or dance and get it now. There were at least 3 instances where the defendant was referring to an enterprise that were in direct relation to his pimp enterprise, having individuals sell sex and split the money with him.
But none of those related to 5th grade girls on the basketball team, correct?
None of them directly did.
Wasn't it wild speculation for this attorney to make that argument in closing argument?
I don't know that it was wild speculation. I think it was pointing out all of these individual facts that were proven. And I think, I guess one thing I would point out is the defendant was specifically asked if basketball travel tournaments wasn't part of your enterprise. He answered no. That could be an unintelligible double negative, or it could be understood as a refusal to deny a relationship between his roles in the sex trade and his coaching program, where he was traveling all over the state of Kansas. That's a reasonable inference that could be drawn from that question alone. The evidence was in the record that he did travel all over the state with these basketball teams, including trying to get exposure for individuals for college programs. He was later asked, is it your testimony today that the enterprise you referred to isn't the 5th grade girls basketball team and your pimp business? It is what again? And the defendant did not expressly deny that the girls basketball team was part of his enterprise. Instead, he claimed that this enterprise was all just a joke. It wasn't just a joke. And I think that's what the prosecutor was trying to drive home. This isn't a joke. The prosecutor did not assert that the defendant was using the girls basketball team as a feeder program. He asked the rhetorical to help illustrate that the defendant's intent here was clear.
So it was rhetorical,
It was rhetorical.
those statements at closing?
Yes. This
Should a
complaint does.
prosecutor make rhetorical statements with respect to a 5th grade basketball team? Isn't that, I understand we allow rhetorical questions, but isn't that a bit inflammatory?
It could be in different circumstances. I would say it's not here. Based on the evidence that was. I think I'm probably up against my time.
You just used your time.
If this court doesn't have any further questions, the state would submit the remaining issues on our brief and ask the defendant's conviction be upheld. Thank you.
Council, let me just lead off with some questions.
Sure.
If your interpretation of the statute is correct, it would be impossible to prosecute anyone under the statute who was arrested in a sting operation. Isn't that right?
It would take a different kind of sting operation. The officer would have to be presenting as somebody who's desperate and looking for money, but not currently in the business. Something like that.
Most of the prosecutions under this statute are result from a sting operation like we had here.
That's right, Your Honor. No, that's absolutely right.
And then my final question, if the statute read inducing another person who is 18 years of age or older to engage in the sale of sexual relations, that would fix the problem, wouldn't it?
Well, to the extent that you see this,
I'm getting to get rid of the words to become. If it said to engage in the sale.
it would undercut our sufficiency argument. Yes, it would, Your Honor. And I think sort of sting operations do come with baggage. That's the reality of sting operations. And I think the result here is the state was left trying to pound a square peg into a round hole, and it just doesn't fit. It just doesn't fit. And I think Hillard is instructive on that point. Hillard is a case where our Supreme Court vacated a conviction for distributing drugs when the theory was that she intended to distribute them to herself. You can't do that. You can't distribute something to yourself. And in the same way, you can't become something that you already are. And we do believe that this court should reverse the conviction on that basis. And for all of the other reasons that we put forth in our brief.
All right, counsel, thank you very much.
Thank you, Your Honor.
For your briefs and your arguments. Second case this morning is also from Sedgwick County. It's 126-682, the state of Kansas versus David Bennett. Who we have here for the appellant?
May it please the court, Sean Randall at the Appellate Defender's Office on behalf of David Bennett, present ready for argument. Your Honors, if I may request 3 minutes for rebuttal.
That is granted. And for the appellee?
May it please the court, Assistant District Attorney Matt Maloney for the state.
You may proceed.
Thank you, Your Honor. I think the case before this panel today is relatively straightforward, Your Honor, or Your Honors, I apologize. Both parties agree that the state and the district court received Mr. Bennett's properly filed request for disposition of detainers on August 29th, 2022. That means that pursuant to the interstate agreement on detainers, his case needed to be tried within 180 days, which would have resulted in a trial date of February 25th, 2023. Ultimately, his trial did not commence until April 10th, 2023. And then the question obviously before this court is whether good cause existed to continue his trial those extra 44 days. My colleague and I also agree that 35 days of continuances from October 3rd, 2022 to November 7th, 2022 were granted for good cause. The difference of opinion concerns those remaining 9 days. That would be the difference.
Well, before we start counting up the days and looking at good cause.
Yes.
How do you get around the Hill case of the United States Supreme Court?
A multitude of ways. I would state that I would at least concede perhaps that the New York v. Hill case cited by the state is at least perhaps instructive or something that this court can look at. But it is by no means controlling or authority that this court has to abide by. What we are examining in this case is a Kansas statute, KSA 224401. And the final arbiter of what Kansas statutes mean is the Kansas Supreme Court.
But the Kansas Supreme Court has said, since this is an interstate compact, we certainly look to other courts. And the biggest court up there is the United States Supreme Court.
That's correct, but our Kansas Supreme Court has interpreted provisions of the United States Constitution different than the Kansas Constitution. I mean, I think Hodes v. Nauser was one of the more recent cases where, irrespective of what the United States Supreme Court case, we found greater protections under the Kansas Constitution. And so what I would argue is that we have directives here from the Kansas Supreme Court that in speedy trial context, that a acquiescence is not enough to waive a defendant's speedy trial rights under the interstate agreement on detainers action.
But those are construing the Kansas speedy trial statute.
Correct.
They're not construing the interstate compact, correct?
That's correct, but I mean, the rights under the interstate agreement are speedy trial rights in, I think in just a different format. We have a speedy trial statute, we have a interstate agreement on detainers statute. I think even New York v. Hill, if I may. I think it's cited in the state's brief, where it said that the New York v. Hill case eventually ended up before the United States Supreme Court, with the issue being whether defense attorney's agreement to a date beyond the 180-day limit waives a defendant's speedy trial rights under the agreement. So we do.
I guess just to wrap up my question, though, do you have any Kansas Supreme Court case saying acquiescence isn't sufficient that's construing 22-4401?
I do not have that in that specific context, but I think I do have it, and I cited it in my reply brief, State v. Queen, which was decided 4 years ago, as opposed to the United States Supreme Court of New York v. Hill, which was 26 years ago. And I think that case is instructive and very clear about what is required in order for a defendant to waive his rights under that statute. And it specifically, I think, indicated that defense counsel's statement confirming he was available for a trial on the specific date offered by the court did not cause a delay that happened as a result of the defendant. Such an agreement was not an affirmative action that prevented a speedy trial. And we have exactly that in this case. We have, hey, I know your trial schedule. Do you want May 2nd or you want May 8th or May 22nd? And the defense counsel says May 22nd. That was a specific trial date offered by the district court. And his mere acceptance or acquiescence to that date is not an affirmative action that would, I think, waive his rights under the interstate agreement on detainers action.
So counsel, I'm gonna give you that. They're looking at the trial schedule and the judge says, counsel, what do you have open this spring? And the defense attorney says, I'm not available in April, but I have some time in late May. Now, under that scenario, is the defense counsel more liable to acquiescence because he ignored April and went straight to?
It would make the argument certainly, I think, weaker. But I mean,
Okay.
I point to Queen because I mean
Well, I have another.
Sorry.
But in here, it was the district court judge who proposed the dates. How does that change anything in?
I think it makes it perhaps stronger. I mean, we don't have. I mean, I think Queen also makes it very clear that making sure that a client is tried within the time limit is a responsibility that falls upon state actors, whether that be the prosecutor or whether that be the district court judge. And, you know, I think the record is replete with the district court saying, you know, hey, look, not my fault. No one told me that, you know, I was supposed to.
Even though the files received from the clerk And this judge would have seen that in court file.
Well, I think the district court said, I'm not, what am I expected to do? Look at a file before I arraign somebody? I mean, I might be, paraphrasing, but it's pretty close to that. And when it's finally brought to his attention, oh, wait, maybe we do have a problem here. He says, look, not my fault. And I think Mr. Bennett aptly said, not mine either, whether it's yours or whether it's the prosecutor's, it's not on me to try me within the 180 days that I requested when I properly filed it, when I sent it to you and it was received by August, on August 29th, 2022.
Let me shift gears here.
Of course.
All right. The last 9 days that the court allowed the extension on because of the court's crowded schedule, he said it was impossible for me to do this any sooner. Why isn't that good cause?
Well, specifically, I think because you alluded to the problem that I would say is that the court is using or quoting, or at least not saying it directly, but that I've got a crowded docket. And a crowded docket exception exists in the speedy trial statute, and it's evidence that our legislature knows how to carve out an exception and use that language when we're talking about speedy trial. It doesn't appear anywhere in the interstate agreement on detainer's action. If our legislature wanted to carve out an exception and say a crowded docket would be good cause, then they could have written it into the statute, because we have another statute where they did write that in, and they did say that. And if they didn't say it in this, I think by reading those two things and seeing that it exists in one statute, doesn't exist in this one, is evidence that that was never intended to apply in this case.
But the statute just says good cause. In the speedy trial statute, you look at who you're charging a continuance to, whether it's the state or the defense.
Correct.
Under the Detainer Act, it just says good cause. And whether the state asks for it or the defense asks for it, doesn't matter. And whether it's the court's reason, it would seem, doesn't matter. You just look, was there good cause for this?
And I would agree with everything that you indicated. You're right, that we don't have to talk about who made the request or who did it. It's just whether or not there was good cause, Your Honor. I would agree with all those points. My argument would be that these states or the district court's failure to take note of the 180 days when trial was initially set, they can't come back later and say, oh, wait, never mind, my fault, good cause, I'm trying to move it up, I'm trying to comply with it, but I just can't do it. So now we get this post hoc, after the fact determination of good cause, to obviate or to relieve them of their mistake and their failure to do what needed to be done under the statute. I mean, Mr. Bennett did everything that he possibly can to get this case tried, and perhaps even more so. There was no need for him to be filing the motion to dismiss on his behalf to bring it to everybody's attention. To be frank, I wish he hadn't and had waited until after 180 days, but he didn't. He brought it to the court's attention and said, you're not going to try me within 180 days. Court says, oh, wait, maybe you're right. I'll move it up. I mean, moved it up a month and a half from when it was originally scheduled, but couldn't do it fast enough and said, I just can't do it. That's not good cause. At that point, it would allow the court to shirk its responsibility and then come back later and say, well, look, I did the best that I can, and I'm sorry I messed up all those times before. I'm sorry, Mr. Bennett, that you kept bringing it to my attention. I'm sorry that you ended up having to represent yourself, but look, I did everything that I possibly can. I think it would invite courts to claim their inability to set it on a docket to avoid their responsibilities under the statute. And I think the court, when it was originally setting it, indicated, at least implicitly, that it could have set this case and it could have tried it if it wanted to. When it said, hey, look, I know your schedules in March and April, so I'm proposing May. I think one could say, well, the reason why he indicated that is because if he had taken note and reviewed the file, like he probably should have when arraigning someone on felony charges, that he could have set a trial date within the March or the March or April timeframe and failed to do so.
No one even was discussing a deadline when they took those dates, is that right?
The state didn't bring it up, the court did not bring it up, and I don't believe that Mr. Bennett's attorney brought it up, which I think that led to Mr. Bennett being so disappointed with his counsel that he eventually, requested and ultimately proceeded pro se.
Mr. Randall, is there anything in the record of the state advising toward any time that this is a detainer act and needs to be tried within 180 days?
I think the first time that I think there were a few mentions of that at the very beginning of the case, prior to the preliminary hearing being set, when he was first brought in on his writ and things of that nature. I don't believe it was re-acknowledged or re-brought to the court's attention until it requested a hearing on March 3rd. March 3rd, they came and requested a hearing before the court, I think recognizing the timelines and saying, we need to figure out what these timelines are because we've got this detainer action. And I believe it's that same hearing when the court then says, well, hold on, why didn't anyone bring this to my attention? I can't be expected to, review a file every time I arraign somebody. And so I think there was a significant break. I think March 3rd probably would have been the first time that the state tried to bring it to the court's attention or re-advise the court of that fact.
You've used 12 minutes.
Oh, okay. Then I will say the remaining remarks for rebuttal unless the court has any further questions.
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. I do agree with what counsel said at the outset of the argument that this is a straightforward appeal. I would argue it's so straightforward because it is controlled by Hill. Now I'm going to start by reading language from Hill because part of the defense's argument is that this is a state law matter because it's a state statute and that this court can therefore ignore Hill. In Hill, the court said, as a congressionally sanctioned interstate compact within the compact clause of the United States Constitution, the IAD is a federal law subject to federal construction. This is not a case where this court is being asked to look at a Kansas constitutional provision or a Kansas statute that is similar but somehow different from a federal law. Of course, in that context, Kansas courts are allowed to determine whether the Kansas statute or constitutional provision offers different or additional protection from a federal law. That is not this case. The Kansas law is exactly what the federal law is, and it's a law that 48 states have agreed to participate in.
You have a pin side from what you just read.
Yes, that is at 528 US at 111 in the Hill opinion. And so because this is a federal law subject to federal construction, our position is that Hill is not just instructive, it is dispositive and controlling. And Hill is so similar to this case, and I would argue that the only distinction really is actually harmful for the defendant in this case. In Hill, basically what happened was the parties were before the court to set the trial date, and the prosecutor basically said, Judge, I think you'd already proposed such and such a date. That works for the state. And the court said, okay, defense counsel, how about you? And the defense attorney more or less said, yeah, that's fine for me. Here, we have more than that. We have a situation where the court specifically scheduled this to accommodate defense counsel's schedule. The court was aware that the defense attorney was not going to be available at least through March because of his trial schedule. And so then he said, He then said, "Is that correct, Mr. Catfield?" And then basically gave 2 dates and said which of these 2 dates would work for you. And Mr. Catfield picked the latter of those 2 options. So I would argue that this was not, first of all, simply agreeing to under Hill is sufficient to defeat the defendant's claim. But here, I think we have even more than just agreeing to. We have a situation where the record clearly shows that the only reason that this case was set out until May was to accommodate the defense attorney's schedule.
I'm gonna interrupt you for a moment. In Hill, and help me out with Hill. In Hill, did the parties clearly hear the parties, including the court, not aware that this is a Detainer Act needs to be tried 180 days from the time the clerk receives this? In Hill, were the parties aware that it was a Detainer Act and therefore they could knowingly acquiesce?
I don't think the record showed that. The Hill opinion shows that they did. It seems like the first mention of the 180 days was well after the trial date was set. I think that it was after the defense had agreed to that date. And then at some point down the road, the defense filed a motion arguing that that time had passed. So I think in that way, it is not any different than in this case, where even if you could argue that maybe they weren't specifically aware of the 180-day deadline at the time that the trial date was set, I think that that's similar to what happened in Hill.
Can I ask you, if we follow your thought, and this is what we see in Hill, it's the state's responsibility, and that's why I keep on asking questions. It's their responsibility to bring the defendant to trial. The 180 days. They just have to be quiet. They don't have to say anything. And then when the district court sets something beyond the 180 days, they can let the defense walk right in that trap. Correct? Because isn't that what we're having here? I'm not saying there's any bad faith on anybody's part. My concern is the policy that we're moving one person's responsibility to another part.
Well, I think I understand Your Honor's point that yes, it is right. Yes, that generally speaking, it is the state's obligation under normal speedy trial case law to get somebody to trial within the time frame. But I think that generally comes from case law interpreting the normal state speedy trial statute, and I think perhaps that's a distinction here within the IAD.
So you're saying the responsibility is on the court for these Detainer Acts, not the prosecutor? As a former prosecutor, I always saw it as my responsibility to get that person in that time. So I'm taking this from personal experience. But you're saying it's actually the court's responsibility?
Well, I think it's also the responsibility based on Hill and the federal case law. I think that the defense counsel certainly has a responsibility here, because we do know that even in a situation where it truly is just acquiescence to a date beyond the 180 days, that does toll the 180-day limit. And another citation and quote from Hill that I cite on page 7 of my brief is that Hill makes clear that scheduling matters, quote, are plainly among those matters for which agreement by counsel generally controls, as opposed to what the client might or might not want. And that makes perfect sense. And I know that that is a little bit at odds with, again, our general state statutory speedy trial analysis, but it does make perfect sense that an attorney obviously is in better position not only to know his or her calendar, but to know whether it's practical to be able to be prepared for a case on a date that's within those 180 days. And that's one thing that I've always found disappointing about our state speedy trial analysis, is to say, well, if a defendant wants to go, even if his attorney is saying, I can't possibly be ready to do a good job in this case, and it almost guarantees that I'm going to be ineffective if I'm forced to try it before I'm ready. Under our state statute, then yes, that does, generally speaking, the defendant's word carries the day. And so I think to the extent I would argue that the way that this is analyzed under the IAD is what makes sense, a recognition of common sense, that the attorney should have the say when it comes to scheduling matters, because a defendant is not going to know the intricacies that require an attorney to get ready. But again, in this case, the situation is simply that Mr. Kepfield had other trials that were already set to go to court. And I cited the Waldrop case, which was a published opinion from this court back in 2011, because I think that does a good job of illustrating what does constitute good cause under the IAD. In that situation, one of the continuances was granted in part because the defense attorney needed additional time because he had been on vacation for a week and he needed more time to review discovery and talk to his client. So if a continuance that is necessitated by a defense attorney's personal life schedule constitutes good cause, I don't think there could be any credible argument that a continuance or a trial setting that is to accommodate Mr. Kepfield's trial and work schedule would not constitute good cause.
If Hill controls here, though, we don't even look at good cause, right?
Exactly, and I do think that Hill absolutely controls, and I think that this court in another 2011 case, this one unpublished, and I'm sure I'll probably butcher the pronunciation, at Beydler, Beydler, that I cited in the brief. This court held in that case that time elapsed during continuances requested by a defense counsel for scheduling reasons is not attributable to the state, and it does hold the time limit of the IAD. So again, I think the main argument that I've heard from the defense, both in their reply brief and today an argument to try to distinguish Hill, is just to say that we're really looking at the state statute here. But Hill clearly says that that's not the case. This is a federal law that is subject to federal construction, and we have a United States Supreme Court case that is directly on point. And again, I would point that the only distinction there is that in this case, it is very clear that the trial date was set specifically to accommodate defense counsel's schedule. And I think in the initial briefing of this case, the defendant himself acknowledged that the record does suggest and indicate that the trial court in this case would have been able to try the case before the 180 days passed, that it was only because he was aware of defense counsel's schedule that he set it beyond the 180 days. So our position is that Hill controls, and that this case is even more clear-cut than Hill, and that the defendant's argument should therefore fail.
Thank you, counsel.
Thank you.
It appears as though the state continues to argue that Hill is controlling and that this is somehow a federal statute. I would note that in the Hill opinion, where it starts talking about a federal statute and that it's subject to federal construction, it's talking about basically preservation and how the case ended up in front of the Supreme Court and how they were able to address it. Mr. Bennett was not charged with violating USC whatever. He was charged in a Kansas district court with violating Kansas statute 224401. We can say it's a federal law. I'll concede that the language is identical to a federal law, but that's not how Kansas statutes, which again, that's where this code is our legislature adopted it and put it in the revised statutes of Kansas. And that's not, the United States Supreme Court does not get to dictate how this court or courts of our state apply and interpret and analyze Kansas statutes.
When Bennett was released from prison, what state prison was he in when he was taken to Sedgwick County Jail?
He was in federal prison in the state of Arkansas.
So. In order for Arkansas to release him to come to Kansas, there has to be a uniform interstate compact like we have here that allows him to be released, right? So we're working within states, Arkansas, Kansas, correct? To move him from the federal prison to Sedgwick County.
I suppose so.
That's the Detainer Act. That's the whole point of the Detainer Act.
Yes,
We're going to release you, and that allows them to be tried within 180 days. So already you're working with two different states, correct?
correct.
So how can you say we should only be looking at Kansas when the mechanism to release them to come to Sedgwick County involves a separate state?
Because that mechanism that you're talking about is contained within the Kansas statute. That's where it has that says, hey, if there is a party state that is part of to this agreement,
Right.
then pursuant to this Kansas statute, you can bring him to the state of Kansas. So I mean, yes, there are other states, yes, there are other jurisdictions that are involved, but I would rely on the fact that what was Mr. Bennett charged with violating, and what provision did he use to file his interstate agreement on detainers, and all of those were Kansas statutes. And I think our court has made it abundantly clear that when a defense counsel confirms that they are available on a trial date on the specific date offered by the district court, that's not enough. That's exactly what happened in this case is, hey, I've got May 8th or May 22nd. Which one do you want? Those are specific dates. He chose one of those dates that the court offered him. That is not enough to waive his speedy trial rights under the interstate agreement on detainer actions, irrespective of what New York v. Hill says. And I'm not trying, and have never asked this court to ignore New York v. Hill. I recognize that the state law that the case law indicates that we can look at other interpretations of this statute as guidance, but we can also look to, or must look to, our Supreme Court's interpretation of what is required in order to waive those. And I think our Supreme Court spoke very clearly 5 years ago that just agreeing to a trial date that the court gives you and saying, okay, I'll choose that one, or that one works for me, or what have you, is not enough. I think it's also, it's frankly upsetting in the sense that to allow Mr. Ketfield to waive my client's rights or waive Mr. Bennett's rights without the record ever disclosing that he consulted with Mr. Bennett, that he asked Mr. Bennett, that Mr. Bennett was even allowed to say anything about whether or not you're okay with choosing this date outside your 180 days. I think Mr. Bennett made it abundantly clear that he was never going to agree to that. I think even when the judge said, hey, best I can do is 9 days after the deadline, he said, I'm not okay with that. I want it now. I want it within my 180 days. To allow his defense, his attorney to waive that without any kind of affirmative disclosure or statement or agreement from Mr. Bennett himself, I think again would fly in the face of the purpose behind the Detainers Act, is so that the state must try him within 180 days. And they didn't do that in this case.
All right, counsel, thank you very much for your briefs and your arguments. They were excellent. You did a great job in this case. We will take a brief recess before taking up the final case this morning, probably just about 5 or 10 minutes.
All rise.
Stay there.
Yes.
Jeff. I speak.
No, not just this week. I think I'm good as well.
One of the rare home games. Well, we're usually across the street. Around the election crowd.
Yeah, absolutely.
Have a good drive back.
You too, thank you. Well, I guess you don't have, right? Just have a good one either way.
Appreciate it.
Here I was thinking, all right, the three issues, what are the problem with them? Got one of them, the other two weren't even legally thought of, which, good. Yes.
What? This whole Sedgwick stuff is a thing, so I asked me if you're talking about that, right? Yeah, it's like I don't, I at least see that when you're stuff there. Nice to meet you. That's what she. So it's a little bit. It's pretty good. Yeah, but once I got, I did some like take out from backwards. Yeah, I don't say. Yeah, you just turn it close. Yeah, exactly. Gina, she from the whole and travel Gina. Yeah, yeah, so I actually texted her tomorrow. If she had something. Yeah, I was lucky. I'm gonna get a Josh, something else, I asked you something. Yes, yeah.
Oscar Brown's here today.
I
The first argument that as president in his council state. He tried to cut off, I think. The only time I've seen him. He doesn't think it's fine. It's rude, so. Turn me to see. Individuals, this all. Just this thing. I think that's. Better figure it. I don't know.
All rise.
Please be seated. We just have the one final case also from Sedgwick County, 128-305, the state of Kansas versus Thomas Eugene Brown. Any comments?
Mr. Brown actually is here in person. He is appearing by counsel, Wendy Miller.
And the appellee,
May it please the court, Robin Summer appearing on behalf of the state of Kansas.
Ms. Miller, do you wish to reserve any time for rebuttal?
3 minutes, Your Honor.
That is granted, and you may proceed.
Well, we're here today to talk about quantity and a motion to correct an illegal sentence. Mr. Brown was convicted of 1 count of possession of heroin with intent to distribute. As far as sentencing, the district court found that there was a balloon of marijuana in Brown's car, that his coat pockets were searched at jail, where there were balloons of heroin found. Now, the district court found that the amount was over 3.5 grams.
I thought he was convicted by a jury.
He was,
Okay, so a jury did convict him for with possession of heroin with intent to distribute
yes,
for that amount. The jury made this finding of that amount of from 3.5 to 100 grams of heroin. Is that correct?
right.
So this is a jury's finding.
And this is at sentencing that I'm discussing what the district court's findings were as far as the quantity.
So, but the judge. The disconnect that I see with your argument is we're ignoring the jury's verdict. The jury's verdict doesn't change from the time they reached the verdict to sentencing. The jury convicted him of 3.5 grams to 100. We don't get to go back and reweigh the evidence at sentencing, is that correct?
Right.
So we don't upend a jury's verdict. And I'll give you a hypothetical. Let's say Bonnie and Clyde are robbing banks, okay? They're going through Oklahoma, Texas, and Kansas, and they rob 7 banks. A Bonnie and Clyde type, present day. And they do a ballistics on review of 5 of the 7 banks, okay? And the ballistics show that the casings left from the bank robber line up the defendants from 5 of the 7 banks, okay? So we have definite proof that they robbed 5 of the 7 banks, but they're charged with 7 because of other evidence that comes in besides the forensics evidence, okay? Under your theory, the jury convicts them of all 7. Under your theory, should they only be sentenced for 5 of the 7 banks?
Well, I think in this case, and what we've cited in our reply brief is we referred to the Lay case. In that case, as I looked over it again, I feel like that case is significant here because that case, the court says that drug quantity is not an element of the crime of conspiracy to distribute marijuana. Now, that case is dealing with distribute marijuana. This case is dealing with distributing heroin. But it's still 21-5705. And that case discusses that drug quantity was relevant for sentencing purposes. So I think the judge could, in sentencing him, look at the quantity and find that the evidence at trial showed that it was under the 3.5 grams.
So now we're having a judge to the fact finding that could increase or decrease a person's sentence. Are we getting into the Apprendi territory?
And that's a good question.
Because I'm concerned. That's why I keep on going back to what did the jury find?
Right, and you're right about that. You're right about the jury's findings. But what the argument is, what the argument he's making under the statute is that the particular part of the statute that shows that somebody's guilty of a level 2 is there has to be 3.5 grams.
Right.
And so his argument is that the lab report showed that out of the bags that were tested, it was under 3.5 grams.
Right, but there was, I'm sorry, good question.
Oh, go ahead.
But there were over eight grams found, correct?
Well, the balloons, everything was weighed, but not everything was tested.
Right, and that was my hypothetical about, you have 7 banks, but you only have certain testing, not of all. Do they, and so here. They chose to test not all 8 grams, but they tested sufficient amount. Correct.
They did a sampling, because there was more than 10 items. The expert said he did a sampling. And out of, they selected these balloons that contained a substance that they were testing to determine whether it was heroin. They randomly selected 18 balloons out of these 40 plus balloons and tested those, and each of them did test positive for heroin. But the other balloons were not tested. So there was only 18 balloons tested and almost 30 other balloons that were untested. We don't know what was in the balloons. And then everything was weighed, is my understanding. And then that's how we come up with that 8 or 9 figure. So what Mr. Brown's argument is that with not testing these items, we don't know what's in it. So the jury was called to speculate by the state in finding that there was 3.5 or greater. It was guesswork.
My question is much broader than any of this discussion. You're trying to reverse his conviction based upon insufficiency of the evidence. What's that got to do with correcting his sentence? That's what this appeal is, from a motion to correct an illegal sentence. How did he get an illegal sentence?
Well, what we're saying is that the quantity that was proved at jury trial was less than 3.5 grams. And so then in sentencing him to the level 2, for which there has to be 3.5 grams, that's where the illegal sentence provision comes in, is because it doesn't.
Isn't there case law that kind of spells out pretty clearly that this does not fit within an illegal sentence claim under 22-3504?
Well, and we talk about the McAdam line of cases, and under Harb and Swisher, where folks were saying that they should be sentenced on a lesser offense where you had 2 statutes with identical elements. But I think what's different about that line of cases is that here we're talking about what penalty to impose based on the weight. And I'm relying on the State versus Lay case that indicates that drug quantity is not an element of the crime of conspiracy to distribute marijuana. I think likewise, it should not be considered an element of the crime here. So if we just look and isolate the penalty provision of the statute, then his sentence did not comply with the applicable statute if there wasn't a quantity of 3.5 grams or greater. And so that's really the argument. We've made an alternative argument in our case too, that if the state is correct, and this is really a sufficiency of the evidence argument, then the court could look at remanding this case back for treatment of this case as a 1507.
Why would we do that? I wanted to talk about that. Why are we making an assumption by saying this should be remanded for something? Or we assume that there's error by the district court counsel?
So if the court views this as a sufficiency challenge, then really his motion should have been construed under 1507 as the argument. Now, he may have procedural hurdles that he's got to get past. He's still gonna have to get past the 1 year time limitation and show exceptional circumstances, which we cite the Swisher case. In that case, I believe the court found exceptional circumstances. And I think they did that based on an attorney's representation through a letter. That there were exceptional circumstances for that issue being raised, and then the court remanded it for a hearing. And so we would say that if it is determined by the court to be a sufficiency claim, then it really should have been construed as a 1507 and then remanded to the district court for consideration under 1507 and whether he can meet the time limitations.
What would be the theory under the 1507? I'm not following that.
If it's viewed as an attack on his conviction, as opposed to an illegal sentence claim. Our position is that it is an illegal sentence, because it involves the penalty provision of the statute that he's provided in his brief, and that this is an illegal sentence.
But if it's a 1507, it would be a remand alleging ineffective assistance of counsel for not arguing
Right,
insufficient evidence on the direct appeal.
that's correct.
I'm gonna revisit the question that Judge Pickering asked you way up front. When the jury found him guilty of possession of heroin with intent to distribute, were they asked on what basis or the drug quantity was? Or didn't you say the jury found him that he distributed between 3.5 grams and 100 grams? The jury found that?
Well, and I would have to look at the record to be sure of that. I know that in arguing and closing, that the state indicated they had to prove that there was 3.5 grams. And that was part of Mr. Brown's argument, was that the state had indicated, that the jury should leap to this conclusion that there was 3.5, even though not all of the bags were tested. That the jury should just decide that this was how much there was, even though nothing had been tested. And so Mr. Brown's argument was then that the jury was asked to speculate on the quantity. So, but in looking at the Lay case, that analyzed the same statute, a different substance, but the same statute, to me, that case almost stands for the proposition that it wouldn't matter whether the state proved 3.5 grams to the jury or some other amount, because the penalty provision of the statute, and that is what you're sentenced for. On a level 2, you would have to have 3.5 grams. But that 3.5 grams wouldn't necessarily needed to be proved. If you look at the Lay case, that finds that drug quantity is not an element of the crime of conspiracy to distribute. So going off of the Lay case, that I think fits with the argument that this should be construed as a motion to correct an illegal sentence, and that it is an illegal sentence, that he was sentenced for a level 2. Should have been sentenced for a level 3 because the evidence at trial did not support a level 2. And that's what we're requesting the court to do, is find that his sentence was illegal, that the quantity wasn't proved, that asking the jury to speculate is prohibited. We don't know what was in the bags, if anything, that were not tested. We have an amount that was under 3.5 grams, and then we're sentencing him for a level 2 that requires 3.5 grams while we don't know what was in the bag. So I would ask the court to find that he did receive an illegal sentence, And that the jury can't speculate on the amount. If the court does find that this should have been construed as a sufficiency claim, then the court has the option to remand for the court to consider this motion as a 1507 and whether counsel was ineffective. And if there's no other questions.
May it please the court, Robin Summer, Assistant District Attorney appearing on behalf of the state of Kansas. There is no way that you can give the defendant the relief that he is seeking without disturbing his conviction. This is a sufficiency of the evidence argument, which is not allowed in a motion to correct a legal sentence, which is what the defendant filed his motion under. In this case, the defendant was convicted of possession of heroin with intent to distribute level 2 drug felony, as well as possession of marijuana and traffic infraction. After conducting the traffic stop, the defendant was arrested and 48 balloons containing suspected heroin were found in his interior coat pocket. The contents of the balloons were tested by the Forensic Science Center, where testing confirmed that the balloons indeed contained heroin. The chemist testified that the lab had a policy of random sampling, and they were provided more than 10 items that appeared to be the same. They do a test and they explain the scientific reasoning behind it and how they get there. It goes into square root of the total to get a statistically representative sample of the whole. So in this particular case, 19 of the balloons were tested. And all of them, testimony was all of the balloons were packaged in the same way. They had a similar size, similar characteristics. And 18 of the 19 balloons tested positive for heroin. In addition, the weight of the balloons that were tested positive came to 3.29 grams. But the net weight of all the balloons together, I counted up and I believe it exceeded something around 27 grams of all of the balloons together. The state argued in closing that the jury could consider and make reasonable inferences regarding all of the balloons together, that the balloons were found all in the same location, that they're similarly packaged, that they have similar appearance, similar size, similar characteristics, and that the jury can make a reasonable inference as to whether the state had met its burden, that the total weight exceeded 3.5 grams.
So that answers the earlier question, Judge Garner, of how much was the jury asked to find a certain weight of the drugs, is that correct?
Yes, and the only issue with regard to the heroin that was before the jury was the charge of 3.5 to 100 grams. The defendant elected to not ask for a lesser included that would have been a severity level 3, that would have been 1 gram but less than 3.5 grams. His counsel was very clear in jury instructions that he did not want a lesser included. He wanted to go to trial on the level 2 and only the level 2. And so the only issue presented to the jury was there 3.5 grams of heroin or more? And the jury clearly found that there was 3.5 grams or more because they convicted him of that count. And so now the defendant is asking to be sentenced on a level 3, when at trial, he was like, no, I don't want the jury to even consider a level 3. But he's now coming back these years later and saying, hey, I want to be sentenced as a level 3. He wanted an all or nothing trial, and that's what he got. And he was convicted of the level 3 or the level 2, the jury clearly finding the level 2.
Was any of this raised in the direct appeal? Just out of curiosity.
Defendant's claim on direct appeal was the district court erred in not giving a lesser included to the level 3. And this court found that that was invited error. Because the defendant was very clear in his statements at the trial that he did not want the level 3, that he was not asking for a lesser included, that he wanted to go to trial on all or nothing. And there was no he could not raise sufficiency of the evidence on the direct appeal either. With regard to the claim that this should be alternatively construed as a 60-1507. The state's position is that this is untimely by multiple years, even if you factored in COVID time. The mandate was of the direct appeal was filed in 2020. The motion to correct a legal sentence was filed in 2024. The state's position is that the defendant has not made any argument regarding manifest justice. And even if there was a procedural time bar waived, this is trial error and not appropriate to be raised at 60-1507. And there has not been argument that his trial counsel was or appellate counsel was ineffective for not raising sufficiency of the evidence at the direct appeal.
If they had, I'm gonna ask you to speculate. If they had raised insufficiency of evidence to direct appeal, it would probably lose. Would you agree with that?
I would agree.
And why?
Because it is an issue of invited error.
Well, no, I meant, even if they said, oh, insufficient evidence for over 3.5 grams, there was still sufficient evidence to support finding out that he was carrying.
Absolutely. I mean, there was all the evidence regarding the location of the balloons, the size, the weight, that it's not a wild speculation to come to the conclusion that the total number of all of these balloons contained heroin, considering that the random sampling shows that 18 of the balloons that were tested contained heroin. So it's not a huge leap to go. The rest of them probably did as well.
Right, it would have been different if they tested 18 balloons and half were heroin and half were not. Then you're entering a question of uncertainty, but here, all of them were tested positive, is that correct?
All 18 of them did,
All 18
yes.
that were tested, every single one came back heroin.
Correct.
Maybe you can help me with stuff that I'm thinking about, because, the Apprendi issue sort of underlies some of this, because it seems like, that the Lake case says, correctly, that normally the quantity of the drug isn't an element in proving the crime. The crime is, possessing with intent to distribute. Oh, what amount? And so now what you're doing to get around Apprendi is to charge a certain severity level or drug quantity as part of the charge and as part of the verdict form. Do you find this was met beyond reasonable doubt? Check yes or no. Is that the way you're doing it?
I can't speak for, I guess I can't speak for the generalities of it. In this case, I believe that the record will speak for itself as far as how the jury instruction was written. But my recollection was that the state had to prove that there was 3.5 grams or more up to 100 grams in order for the jury to be able to convict on this count. And so that was what the jury was faced with addressing. And so the weight was included as an element in this case. And again, the record would speak best for that, but that is my recollection.
And conspiracy to distribute is quite different, right? In terms of weight, because you're looking at the conspiracy part, the group agreement to distribute drugs.
Yes, I think that has additional elements rather than just and the statutory requirement here was if it was 3.5 or greater, it was considered distribution amount without needing to have evidence of other elements for conspiracy, but just the mere possession provided a rebuttable presumption that that was distribution. If there's no further questions.
Your client is still serving this sentence, right?
He is on post-release,
Okay.
yes. And really, the only thing that I would finish up by saying is that I believe that if the sufficiency was looked at, that it wouldn't be sufficient. Because we've got such a small amount of a drug, and I'm not an expert on drugs in any way, shape, or form. But when we're talking about 3.5 grams, that's a pretty small amount. I don't know that you could just look at an item that contains whatever amount of this substance and decide, oh, well, it looks the same as these other balloons that were tested and these balloons all tested positive. So I don't think it's as cut and dry as that. I don't know if the balloons were taken. It's my understanding that they were in a sandwich bag. I don't know if they were taken from the top of the sandwich bag. There's a lot of room for question because we don't know what was in the bags. So that's more of a leap, I think, than could be made on the sufficiency. And with that, I'll submit this case for your consideration. Thank you.
All right, counsel, thank you very much for your briefs and your arguments. We appreciate it. We'll get a written opinion out to you just as soon as we possibly can. And with that, court is in recess until 1:30 this afternoon.
All rise. Mr. Clerk, over to you. Don't you? It's weird.
So 1/3.
That's kind of think the same thing. You know, so it's big up there, so really. Did you watch Lanterns? Pigeons?
Gillette. Nice to meet you.
Thank you.
I left it.
Okay, well, let me, give you something that, her.
All rise. The Court of Appeals for the State of Kansas is now in session. The Honorable Thomas Malone presiding.
Please be seated. All right, we are here for the afternoon session, and let's just jump right to it. The first case is from Sedgwick County, 127-543, State of Kansas versus Troy Henry Nelson. Counsel would come forward. We have Mr. Gillette for the appellee and
David Pachacon for the appellant.
say your last name again.
Pachacon, just like it's spelled, right?
Just like it looks. All right, do you wish to reserve any time for rebuttal?
3 minutes, Your Honor.
That is granted. Begin whenever you're ready.
Take the podium.
Yes.
Yes. May it please the court. My name is David Pachacon. I represent the appellate Troy Henry Nelson. We briefed 5 issues, though I think that for the sake of brevity with the time that we have today, I think there are 2 that I believe most warrant oral argument. The first being the issue of the amended information, which is issue number 1. I have to start by conceding that as the state indicated, this issue wasn't preserved. That was noted in my brief. Though I disagree slightly with the state that this issue can't still be dealt with here on appeal. I could have done a better job. I have to concede in briefing this issue as a non-preserved issue. This to provide some backstory, though, I understand that your honors have read the briefs. The state amended the information at preliminary hearing to add a count of premeditated first-degree murder, attempted premeditated first-degree murder, though the preliminary hearing court stated that they could not add that as a separate count, that it had to be added as an alternative. The state argues that this was an error as the court applied the wrong multiplicity argument. However, that was the order of the court that was given at preliminary hearing. There was no motion to amend that. There was no motion to reconsider at the preliminary hearing. However, approximately 6 days prior to trial, the state amended the information unilaterally without requesting leave of the court. Unfortunately, Mr. Nelson's trial counsel did not object to that. In fact, as the state notes in its brief, defense's jury instructions listed those counts as separate counts, as not in the alternative. Mr. Nelson, neither through counsel or by himself, objected to this amendment and proceeded to trial on that amendment.
Counsel, I'm looking at your brief.
Yes,
On page 6, it says standard review and preservation of the issue.
yes,
But I don't see that you address preservation.
yes, and that's where I have to, I'm sorry.
No, so you have the title there, but no address, correct? Yeah, standard review and preservation of the issue. So if I read it, I'm thinking I'm gonna hear about whether this is preserved or not, what exceptions apply.
Yes,
And that is not done, is that correct?
yes, and that's where I must concede that I could have done a much better job addressing that issue. I do address the lack of preservation in the body of the brief. And I do address, though I don't cite to the authority or the exceptions, I do address Mr. Nelson's fundamental rights being violated by this amendment. Though, as I said, I have to concede and candor to the court that I should have done a much better job briefing that issue.
You briefed it more directly in the reply brief, correct?
Yes, I did, and I understand that the case law is clear that a reply brief cannot remedy this issue. So I did address the issue as I was drafting the brief, though I have to acknowledge that in the preservation section, I did not specify the case law as to why the exception applies. So without assuming that the court is not going to address this issue, it was improper for the state to move to, or not even move, but to amend the information without leave of the court. And the district court, though I believe that the district court wasn't fully informed, as I noted in my brief, neither Nelson's trial counsel nor the district court judge who heard the trial were present at preliminary hearing, which I think might have been part of the issue as to why this wasn't objected to by either the district court or Nelson's trial counsel, though trial counsel should have been better informed of the posture of the case. So I cite in my brief that this is an abuse of discretion issue, and I believe that though the district court likely was not even fully informed on the issue was decided, if in so much as it was decided based on a lack of sufficient factual evidence. As far as the district court doesn't appear to recognize that this issue had already been dealt with at preliminary hearing. The district court had already, or the preliminary judge had decided that they couldn't be brought as separate charges. And then, as I've noted in my brief, this prejudiced Mr. Nelson due to his inability to properly prepare for trial, strategize for trial based on this, going into trial, assuming that these were going to be alternative charges. had, since this issue was already determined at preliminary hearing, adding these as separate charges again should have come with a new probable cause hearing.
Well, you would have to have probable cause to put in the alternative.
Yes, yes, and I understand, I agree with
And the
that.
defendant would have been advised of the punishment associated with at the arraignment.
Yes. Yes. And the next issue that I believe is most appropriate for oral argument today is Mr. Nelson's claims of ineffective assistance of trial counsel. This might even be slightly more convoluted than the amended information. Mr. Nelson had multiple attorneys during the trial phase. Ms. Corrado was brought on after preliminary hearing. And I believe there were several errors that deprived Mr. Nelson of his right to a fair trial. There is disagreement between myself and the state on whether this issue is right for hearing here at the Court of Appeals. I acknowledge that generally speaking, a claim of ineffective assistance of trial counsel can't be brought for the first time on appeal. I think the disagreement would be whether it was brought, whether it was attempted. Mr. Nelson filed on July 27th, 23, a motion for new counsel. Though it was titled as a motion for new counsel, he cited to the Strickland criteria, and he cited that he did not receive effective assistance of counsel prior to sentencing, where the judge heard this motion. He filed a second motion for new counsel, and at the top of that motion, he specifically cited a request for a Van Cleve hearing, and he cited again the Strickland criteria for ineffective assistance of counsel. Now, there's nothing in the record that indicates that the trial court treated this as a motion for ineffective assistance of counsel, though he did rule that he felt that trial counsel provided competent representation and then moved on. So Mr. Nelson, through his pro se filings, did attempt to address this at the trial court. I guess we can presume that in finding that his trial counsel was competent, maybe that was the judge ruling that he received effective assistance of counsel. Though I think that it's gray enough that I don't believe that the issue was addressed at the trial level, which is why I briefed it as not being addressed at the trial level. Yet I believe that based on the clear record in the case that this could be addressed. To
refresh my memory, you asked for a Van Cleve hearing with our court as well, is that right?
I did not. He did have appellate counsel prior to myself.
And it was denied?
It was denied. It was filed as a request strictly because my client said he wants one. So there wasn't much explanation given in that Van Cleve request, though I did not file a subsequent one as I viewed the issue as addressed and I moved on.
But how could we possibly review it without any kind of an evidentiary hearing?
I agree that that would be the most appropriate way. However, Mr. Nelson is put in a pretty bad spot as someone who is sat in jail and now prison for quite some time. He sat in jail the entirety of the couple of years waiting on his case to conclude. And then he attempted to address this issue at the trial level through his motions, though he didn't title them as a motion for ineffective assistance of counsel. I think the trial courts are instructed to view the content of the motion and not necessarily the title on these pro se motions in order to adequately address the issues. And I think Mr. Nelson addressed that these were ineffective assistance of trial counsel motions. I don't think it helps this court because no record was clearly made. Ms. Corrado was given the opportunity to respond to his multiple concerns and just stated that she wasn't going to. Now, perhaps she didn't view that as a motion for an ineffective assistance. And she did state in her response that if she were put on the stand, she would. So perhaps she was viewing this as not an ineffective assistance hearing, so if this becomes one, then I'll obviously defend myself, but Mr. Nelson's put in a tough spot of, do I wait for this appeal to run its course and then file a 1507, which it would be the normal course of action. That doesn't obviously mean that this court has to hear it because Mr. Nelson should get a chance before 1507. So I'm not claiming that that's a reason why the court should hear it, but I do think he attempted to address it. I think the record's clear enough on the issues. If we were to take just the issues that we know to be true that are not disputed, and I, as I briefed, Ms. Corrado's refusal to defend the accusations that Mr. Nelson essentially made his accusations uncontroverted. And if we were to take those uncontroverted claims as the facts, because that's all that we have, then I believe that this court can look at the fact that she didn't have sufficient contact. Now, I do agree that the record, as the state noted, the record shows that maybe Mr. Nelson was being a little hyperbolic when he said there was no contact, because I do think the record reflects that there was some contact between counsel and Mr. Nelson. There wasn't any sufficient review of discovery, specifically text messages between Mr. Nelson and the victim that were entered without objection, without review with Mr. Nelson of, did you make these text messages? Is this you? What did you mean by this? I think that that's very clear, that it's clear from the record, from his objections, that they weren't reviewed with them.
Could there be some benefit in waiting on pursuing an effective assistance of counsel until after the direct appeal is over, and you're then able to sit through and go through the entire record, because you only get one 1507.
Yes.
And that's one reason why attorneys will wait till the whole record's done, and then they go through everything that happened at trial.
Yes.
Hearing, sentencing, versus here, if we do follow your argument, it should be addressed. Your client is limited to their arguments present. So could there be some benefit of waiting to have a 1507?
Yes, I don't disagree that there would be some benefit to that. I think the most appropriate thing would have been for the trial court to treat his motion for what it was and have that hearing prior to sentencing. But of course, that didn't happen. So I do recognize the benefit to giving him his full evidence here, yes.
You've used 12 minutes.
Thank you.
May it please the court, Assistant District Attorney Lance Gillette on behalf of the state. I'll confine my arguments today to issues 1 and 3, as opposing counsel did here today, unless this court directs me otherwise. Respectfully, the state maintains, and the defendant candidly admits in the reply brief that in issue 1, the challenge to the amended information was not preserved. That he tries to brief a preservation exception for the first time in a reply brief, which he cannot do based on controlling Kansas Supreme Court precedent.
How exactly was the amendment of the information amended?
That's a fair question, and candidly, we don't have the full details. What the record does show is the First Amendment happened following a preliminary hearing.
Well, I know that, but the judge ordered it needed to be alternative, and then about a week or so before trial, it appears the state just filed an amended information.
Well,
am I right on that?
I can't answer that 100% clear, because what happened was the state does file this, but there's no indication that there was any failure to communicate or seek or obtain the court. The record indicates that the court recognized that this amended information is there, made sure that the defense was aware of it, The defense had no objection to it.
Was there what you're describing now, did that take place at a hearing?
Yes, yes, the district court did note that prior to the beginning of trial. Yes,
At the beginning of trial,
yes,
the judge said something like, you're aware that there's an amended information here, right?
correct.
And defense counsel said yes.
Said yes, and we
Okay.
proceeded to trial.
All right.
Yes, and so what if any other communications that had gone on, we simply don't know. So we would respectfully maintain that the defendant's challenge to the amended information is not preserved. And as an alternative, as the state points out, the scenario here that I just discussed with Your Honor, that effectively constitutes a waiver of any ability to challenge the amended information pursuant to KSA 22-3208 subsection 4. I noted the Dunn case in my brief and just again reiterate to this court that if a defendant, the only way to escape that waiver is for a defendant to make a claim and demonstrate the cause for why he should not be held to his waiver. There's been no attempt to do that here. And an example from Dunn is that if a defendant could demonstrate that a charging document was so bare bones that he or she was unable to appreciate an infringement of their due process or notice rights until the evidence began or came in at trial or later, that's an example of something that could constitute cause shown. We have nothing of the sort here. We have a record where the defense, with the defendant present, was fully informed about the charges that he was proceeding to trial on, made no objection, and proceeded to trial. As far as I'll just stand on my brief in regard to the lack of merit as well. I would just briefly summarize that portion or that alternative argument that I made, that I think it is pretty clear in the record here that the preliminary hearing judge that was helping to unwind the cases from the COVID era misapplied the multiplicity test. It was pretty obvious that he applied the single act of violence test. The defendant has no right to that misapplication of law. And so again, I think that the amendment was appropriate here. Defense counsel not objecting to that amendment for that reason, I think was also absolutely appropriate. If there are no other questions on that issue, I would move on to the ineffective assistance claims. As noted in the state's brief, ineffective assistance claims are not ordinarily addressed here for the first time because they involve mixed questions of fact and law. And candidly, as the state asserted in its brief, the 6 various claims that are made here, candidly, they are all completely refuted by the record here based on what's in the record right now. So initially, the state would say that this court cannot reach those claims. And in the alternative, should this court elect to, you can just deny them all because they are all meritless. It was clear, defendant's first claim that trial counsel had no communication with him prior to trial is simply not true. It is controverted clearly in the record. They were clearly working together. I guess before I address each of these points, I would also note here it is clear the district court did not treat this as an ineffective assistance of counsel motion. It treated these 2 documents at record volume 180 to 94 as a request for new counsel. Notably, those 2 documents, you cannot look at those and see that those were written by the same hand. There's no indication that this was actually coming directly from defendant. There's no indication or record about what, if any, resolution was reached between defendant and his trial counsel to allow them to proceed. Candidly, the defendant's argument at the motion for new counsel was far-ranging. It targeted previous attorneys, the court, the state. It was just kind of a scattershot argument out of frustration. not directly bearing on ineffective assistance of counsel. So that would bring me back to the 6 claims that were made. I've already addressed the first. It is also clear that trial counsel reviewed discovery with the defendant. The 103 pages of text messages being the only one that he attempted to complain about here. I would note that for each and every one of these, trial counsel was also clear that should these 2 motions have ever reached the point of considering them claim for ineffective assistance of counsel, she would have offered explanation contrary to defendant's claims. But again, we didn't get to that point. Third would have been the claim about a failure to object to the amended information. That's simply repackaged issue 1, then not calling the daughter as a material witness. There's simply no basis. It's other than conclusory statements in support of that. The daughter was available. She was actually held on the state's material witness warrant in this case, and after consulting with the defendant personally multiple times, he and trial counsel agreed to let her go. And so she was discharged from that warrant.
So the victim's daughter never testified in the trial?
No,
How did they get in all the evidence about the phone call that the defendant made to her?
it came in through the victim EL, who testified that she had been present and heard the defendant's voice on that phone call. The recording was done by the daughter, and it appears that it was trial counsel's strategic decision to allow that to come in with that form of foundation. And candidly, it was a wise decision because it did put before the jury an unchallenged alternative version of events from the defendant that the state was not able to cross-examine him. So it was a well-timed, well-thought-out decision, candidly, and a strategic one that is not really subject to an ineffective assistance of counsel claim. The claim that trial counsel persuaded the defendant not to testify, the only thing that's actually clear there is that the defendant did not testify. And in fact, what the record bears out is that he agreed with counsel's advice and exercised his right not to testify and told her, "I trust." That was record volume 10, page 5. And then finally, the ineffective assistance overall, the state maintains that that was a purely conclusory claim. And with that, on those 2 issues, the state has no further argument unless this court has specific questions about those 2. Seeing none, the state would maintain that there was sufficient evidence to support defendant's convictions. His challenge to the amended complaint and the ineffective assistance of counsel are not properly before this court. Actually, before I sit down, I do want to note one thing about issue 4 that wasn't talked about earlier. This court is likely aware that last Friday, the Kansas Supreme Court issued an opinion in Brown, and it's slip opinion 128178, that clarified our case law on how claims for mistrial are to be construed. The briefing here gets close enough that this court could certainly apply that clarified test from Brown to how the parties briefed that issue in this case. There was an inadvertent mention from EL that the defendant had been in jail. It was clearly inadvertent. But arguably that would have constituted prejudicial conduct in court. However,
nevertheless, the district judge found that there was no fundamental failure, right?
Correct.
Which of course now you don't use that term.
Correct.
And you would agree that that doesn't prevent us from still reviewing the mistrial analysis, is that right?
That is correct. I think that this court is Barring any kind of a motion for rehearing or modification in Brown, I think this court is duty bound to adhere to Brown, apply that analysis here, and I think that the briefing is sufficient to allow this court to do just that. And I think that the remedial measure taken by the court, making an extensive record about how this inadvertent statement came about, that it was passing, that it was not nearly as harmful as the reality, that defendant had been in prison, that there had been other redactions throughout their evidence in this case to obscure that reality so as to not prejudice the defendant, and then ultimately to instruct the jury that, quote, you must disregard the testimony of EL that the defendant had been in jail prior to the date of the attempted second-degree murder here.
Do you plan to file a 609 letter now that you're talking about it? Or argument? I've been trying to figure out what the.
And this is kind of it's a tricky area because while that opinion is out there, the time for a motion for rehearing or modification is not yet run. I do have the ability to file a 609 letter once the case is final, and I believe that would be my intent at this point, would be to file that letter.
Wait the 21 days.
Correct. Once that time is run. If there are no other questions, I thank this court very much for its time and would ask that the defendant's convictions be upheld. Thank you.
Please court. And Your Honors, I just have a little bit of rebuttal based on what the state stated. Specifically regarding the amended information, the state indicated that there was no failure to communicate based on this amended information, and I would simply note that there's nothing in the record that shows that there was any communication. It appears from the state's brief that the state's intent on filing this was to correct what it perceived to be the preliminary hearing judge's misapplication of the law. And that's something that I think the state should have done if it wanted to. However, there's nothing in the record that shows that this was done or communicated. The discussion at the beginning of trial regarding this amended information was just, there's an amended information filed, there was a count removed. And the state replied that we didn't remove a count, we simply removed the in the alternative language. That's the only thing we have in the record regarding this amendment. There's nothing that states that it was communicated to the court or defense counsel prior. As I've already said, and I think this goes more to the ineffective assistance claim that this court may very well kick to a 1507. The trial counsel should have recognized that this was done inappropriately and without seeking leave of the court, and should have objected. We can't speculate as to, what would have happened after that. Regarding the ineffective assistance of counsel claims, I would just state that once again, I think it's very clear from the record that counsel was ineffective. So if this court does decide this issue today rather than leaving it for 1507, this case was essentially a he said, she said. Mr. Nelson never denied that he was in the car. He never denied that they were in an argument. He never denied that the vehicle went off the road and that he then drove around the city for a while before the victim jumped out of the vehicle and Mr. Nelson drove off. The issue, the disagreement, and what led to the most serious convictions in this case were that why the car went off the road, why Mr. Nelson grabbed the steering wheel, and the fact that Mr. Nelson was not able to give his side of the story is based on this entire string of ineffective assistance of counsel. Had counsel sufficiently contacted Mr. Nelson, had they had sufficient time to prepare for trial, had they reviewed this discovery, specifically these text messages that were admitted without objection, without providing any foundation, without Mr. Nelson being able to rebut them because he relied on his trial counsel that he didn't need to testify. There isn't anything on the record showing that why he, chose not to testify. The trial court did not put it on the record that he wasn't going to testify, other than, have you had sufficient time to have your conference? And she said, yes, we rest. That's the only thing in the record about his decision not to testify. The decision to let this witness go without being there to provide more foundation for the recording. And then, as I stated in my issue of overall ineffective assistance, trial counsel was admonished a couple of times about her choice to cross-examine witnesses simply by getting them to reiterate what they said under cross or under direct, and taking more time to do so than direct. So I would argue that if this court does decide to handle this issue of ineffective assistance, that the record is clear from what we have, that isn't controverted, that counsel was not effective and that he did not have a fair trial based on that. There are no other questions. I would rest.
All right, counsel, thank you very much for your briefs and your arguments. We'll get something to you as soon as we can. Last case on the docket from Sedgwick County is 127-416, Jeremy L. Collins versus the state of Kansas. We have Miller and Mr. Maloney here arguing. Do you wish to reserve any time?
Wish to reserve 2 minutes, Your Honor.
2,
Yes, please.
that is granted. You may proceed.
Start out with in this 1507 appeal. The first issue we've raised in our brief is whether or not there was probable cause to arrest Mr. Collins for trespassing. And based on the facts, we maintain there wasn't, with what law enforcement knew at the time of the arrest. He was in the hospital seeking treatment for injuries to his feet, having trouble walking. He says his feet were bleeding. But he kept coming out of his room. He was asked to stay in his hospital room, and then eventually he was asked to leave. So he went down to the entryway in the ER, and security followed him out. But it happened that a Wichita police officer was also on duty on an unrelated case and ended up following Mr. Collins out of the hospital. He was in the process of leaving, and when Officer Bebb said he got concerned because he saw him pull out a screwdriver from his pocket. At that point, he was leaving, and the decision was made once they got outside to arrest Mr. Collins for trespassing. So at that point, our argument is that once they were outside, he had left, he had done what he was asked to do. He wasn't trespassing any longer, and that he had left like he was asked. And so our contention is that there was no probable cause to arrest him for trespassing. He was never charged with trespassing. During the process of arresting him for the trespass, facts developed that led the state to charge him with the assault on a Leo. And our contention is that this was essentially a continuous event from the time that he was arrested for trespass to all the events that ensued. It was a continuous event. There was nothing intervening in between the time he was arrested for trespass and taken into custody and the actions that led to the subsequent charges for aggravated assault. There was nothing to interfere with that. So
Can you help me even if we agree, he shouldn't have been arrested, you still can't erase the fact that he assaulted the officer, is that correct?
Right, I mean, I don't think that, he's asking the court to do that, but
Cause that's how I'm reading your argument. As well, if you take away his arrest, we get to ignore the assault on the officer. That's how I'm reading this. Tell me why I should, help me out.
So that's what our argument is because of this unlawful arrest, if you, assuming arguendo, you find that the arrest is unlawful for trespass. If the actions that occurred during this arrest then led to the aggravated assault charges and there was nothing that interfered with that or stopped one event and then started another event, nothing to separate the unlawful arrest from the actions and activity that was occurring that led to the state charging him with the aggravated assault. So
Here's what I thought. Police officer sees somebody not speeding, pulls him over, does a car stop with no reasonable suspicion. Okay, we're moving it from cause reasonable suspicion. Person who is driver hits the officer. Okay, when he pulls him over, pulls the car over without reasonable suspicion, the driver hits the officer. Is that the same argument you're making that we can, if there's no reasonable suspicion, we get to ignore the battery on the officer?
well, in this case, he was arrested for the trespass. He wasn't arrested for the assault. So I think because the officer said that his probable cause to arrest was the trespass, which we're arguing did not occur, the facts did not give rise to trespass. That's what the difference is in the argument.
Do you have any comparable cases that sort of apply this rationale with the chain of events or continuous nature you're talking about?
Nothing specific. We've got general cases that are cited in the brief, but nothing specifically on point. The other thing that I thought was important in our brief to discuss with the court is the ineffective claim that Mr. Collins raised against trial counsel for requesting the competency exam. And anybody can request, any party can request that, the judge can certainly order that. But what Mr. Collins is indicating is that counsel requested this because Mr. Collins was disagreeing with continuances and was disagreeing with him. Counsel then requested this competency exam without having any kind of facts like contact with family members, medical records, any kind of factual basis or reason to believe that, this was something that was needed.
Well, he would have his conversations with Mr. Collins as a defense attorney. Those conversations would warrant enough question or concern that the person may not be competent. Is that enough?
I think under circumstances, yes, that could be enough if that was something that was articulated. Here, the contention is that it was requested because he was disagreeing about the continuances. But I stand on the record for what his reasonings for requesting it is. I think the district court just ended up finding, well, this is in your best interest, and so I can either have it ordered or words to the effect that he was just going to order it because it was in his best interest, and then if he was found to be competent, then everything would proceed. So I don't know that the district court made specific findings based on what trial counsel said, like, hey, I'm having real difficulties communicating. I think they were having disagreement. I don't think there was necessarily an issue with the communication that was raised. But yes, I agree with you. It could be based on counsel statements that, hey, I'm having real difficulty here. I can't communicate with this person. But I don't think that's what it was here. I think it was here more so just the disagreement between the two on continuing trial.
Are you familiar with a case where a defense attorney has filed a competency request on a client? Because there's disagreements with respect to continuances?
No, I'm not. And as far as the speedy trial issue, we've raised, Mr. Collins feels that it's significant that when this court addressed the speedy trial issue on direct appeal, that the authorities in case law on whether or not he acquiesced and how it should be attributed, how each period of delay should be attributed wasn't considered under the certain authorities like Brownlee, Vaughn, and similar decisions. On the constitutional speedy trial issue, the district court had found that an 8-month delay was not a significant delay. But when you look at each of the Barker versus Wayno factors, it starts to weigh in Mr. Collins' favor that there very well might have been, and especially if it started, the speedy trial clock started in August. And that was one of the, circling back to the competency issue, the reason why Mr. Collins says that he was prejudiced by that is because there was a 23-day delay that took place because of that. And yes, the court, I think, ended up giving him some of the credit back for that, but it still caused some delay that was charged to him. And I think this court ended up finding that he was 15 days short of meeting the speedy trial violation. But going back to the constitutional speedy trial claim, Mr. Collins had requested, he had objected to continuances. He filed his own motion for speedy, to dismiss for speedy trial violation. So he definitely raised objections and filed his own motion to try to protect his rights. And so under the Barker versus Wayno factors, we think you look at all of them and balance each of them. Collectively, those factors weigh in his favor, and that he had a constitutional speedy trial right violation. The other issue that I think was significant to Mr. Collins was that he had indicated appeal counsel was ineffective because appeal counsel didn't raise prejudice in discussing. One of the flaws in the jury instructions was that how the term knowingly was defined. And he's asking that the court remand this back for an evidentiary hearing. And he believes that he's asked for a rehearing on all of the issues that were raised in direct appeal. And so I don't have additional argument on that. I just wanted to clarify what he's asking.
The knowingly, how it was defined, he's saying that was error. Is that correct? That you said appellate counsel should have challenged the knowingly? I want to make sure.
I guess what his argument is that even if there was an error, that appeal counsel had not shown prejudice with the definition, and he thinks that the facts, the way that the facts were interpreted was that he raised this knife when everybody was advancing, and he maintains that's because he was in fear, not that he was trying to charge anybody or attack anybody or had any intent to do so. That he took this screwdriver out because he was being hogtied. He had been tased several times. Somebody that was a medical tech had given him narcotics, and he was in a sleepier state. And so his main contention is that he did this out of fear because he had all these people ganging up on him, and he was scared. He didn't intend to hurt anybody. He was scared.
You've used 13 minutes.
And if there's no other questions.
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. I guess I'll just start with this issue of the validity of the arrest. From a factual standpoint, that argument fails because essentially what the defendant has done is isolate one piece of testimony from one of the officers to try to support his claim that the officer essentially indicated that there was not probable cause to arrest for trespassing. But when you look at the totality of the testimony, the officer had already testified that he had made the decision to arrest him because the defendant had ignored several demands to leave the property. So from a pure factual standpoint, he's not entitled to relief by isolating the testimony where he was asked whether the defendant was committing a crime at one specific point in time.
So, Mr. Maloney, is this argument that factually there was not probable cause?
That's the way that, yeah, I think that's the way I understand the argument from the defendant, is he's saying that there was not.
And hasn't the US Supreme Court ruled that officers get a leeway with respect to they're wrong on the facts?
And that would be my second part of that argument, is that even if this court were to somehow disagree with the officer's assessment of probable cause, I think Your Honor's questions to opposing counsel gets to the part of the fact that that doesn't then mean that even if this court were to have a different assessment of whether probable cause existed, that then the defendant is entitled to assault an officer just because the officer had arguably made a mistake in determining whether there was a basis for the arrest. So from both a legal and factual basis, that argument fails. I think your traffic stop analogy is a good one. In this case, obviously it was assault when he pulled this screwdriver, but let's extend it further. If the defendant's argument were accepted, then if the officer had improperly determined that there was probable cause for trespass and the defendant had pulled out a weapon and shot and killed the officer, could we say, well, then we can't prosecute him for murder because there was no basis or no proper basis for the trespass arrest, and therefore it's just kind of no holds barred that the defendant then can't be prosecuted for any crime that he commits after that allegedly improper arrest. So again, for both factual and legal bases, I think that that argument is without merit. Next, turning to the competency evaluation. I think that in a way that is very similar to an issue that was ruled on direct appeal. He raised general claims of ineffective assistance and justifiable dissatisfaction with counsel, where he questioned some of the tactics that counsel utilized, and this court rejected that, said that he had not shown justifiable dissatisfaction. He's essentially just repackaging that now to add a specific argument with respect to these competency evaluation. And I would argue that he should not be allowed to raise that when that's something that easily could have been raised specifically on appeal.
Is it something he can't raise because it was already raised below, or he could have raised it below? Which one is it?
I think because it's something that could have been, the specifics of it could have been raised. I guess you could look at that either way and say that it was raised in the sense that they did raise issues with counsel. And so now he's just trying to repackage it in some way. But even if you were to say that it was not raised at all below and that this is a totally new issue, just skipping to the merits of it, clearly there's no requirement that an attorney has his client's permission or consent to seek a competency evaluation. The statute's
clients fight competency.
Exactly. It would be the ultimate catch-22 if an attorney could only properly seek a competency evaluation with their client's permission. And so again, just cutting to the merits there, I think that argument fails. The statute clearly does not require permission or consent. And as Your Honor pointed out, it's far more likely than not that the client would oppose it, but that still doesn't mean that the attorney, if he or she sees a basis for concern, is not properly allowed to seek a competency evaluation.
I'm gonna throw you a softball. Okay, I've learned it's better just to start labeling them because people think I'm throwing a hard question, I'm really not. Isn't it the right of a defense attorney to ensure their clients' due process rights are upheld?
Right.
And would it be a due process violation, so two-part to a softball, for somebody to appear at their own trial incompetent?
Absolutely. And so, and that absolutely is correct, and that's why it is important that attorneys have the ability to take these types of steps on behalf of a client when maybe the client, him or herself, does not realize that it is in their best interest. Turning to the speedy trial, the statutory claim is res judicata because on direct appeal, this court did specifically find that he was tried 15 days before the statutory deadline. And so there's really no way to revisit that. Looking at the constitutional claim, our position is that that is also clearly without merit. The delay in this case was 8 months. There's no hard and fast cutoff or a time period for a constitutional claim as far as whether it meets that threshold to even get past that first inquiry. But generally speaking, the cases where they have found that it gets past that are well more than 8 months. Out of an abundance of caution, just to address the other factors though, the reason for the delays, in this case, there were no state continuances. So all of the continuances, all of the delay is attributable to the defense. The assertion of the right, while the defendant did, I believe at certain points, request a speedy trial, he also did personally request one continuance. So that action is contrary to the assertion of the right. And then that final factor, the showing of prejudice, he's made no attempt to show any particularized showing of prejudice. And the case law talks about the fact that defendants can't just make a generalized statement that I was prejudiced because I was incarcerated or because witnesses' memories may fade. You have to make some particularized showing, and he has failed to do that. The last category of arguments, I think, are these ineffective assistance of appellate counsel claims. I think specifically the talk today was about this instruction. And I think there were really two instructional arguments that were made in the brief and in the motion. And one of them had to do with the defendant saying that appellate counsel was ineffective for incorrectly conceding that the movement did not object to the definition of knowingly in the elements. But the record shows that when the defendant was asked if he had an objection to that instruction, he replied, "No, looks good." So clearly, counsel was not incorrect on appeal for the way that he framed that. And then there was this other issue with failing to establish reversible error with respect to an instructional challenge that counsel raised on direct appeal. And I think it should go without saying that the mere fact that an appellate argument proves to be unsuccessful is not an indication of either deficient performance or prejudice. We all know, all of us in this courtroom know that the vast majority of arguments that are raised on direct appeal by a criminal defendant are far more likely than not to be found unsuccessful. Certainly, they're not likely to reach the level of showing prejudicial reversible error. And so just the fact that counsel raised an issue that didn't ultimately lead to relief for his or her client is not a sign of ineffective assistance of counsel. I think I've addressed all of the categories of the arguments that the defendant has raised. It's, again, our position that some of these claims are not properly before the court because they've already been decided on direct appeal, and that those claims that are properly raised at this point are without merit from both a factual and legal standpoint. We would respectfully request that the district court's decision be affirmed.
Just very briefly concerning the competency claim. The discussion was whether that was raised previously or not, and the claim that his trial attorney was ineffective for requesting a competency evaluation would not be appropriate to raise in direct appeal. And I also think it's significant that he was found competent. And would also refer the court to the case law that cites to the cases that we have in our brief. It's either our brief or our reply brief about defendants being presumed competent.
Could you repeat that first part? I want to make sure I'm very clear. So on this direct appeal, did the panel weigh in on effectiveness or not? Or
The panel did talk about whether there was a conflict with his attorney. So that was addressed, but this issue with whether his trial counsel was ineffective for requesting a competency evaluation was not part of the consideration.
when they discussed conflict, did they talk at all about competency? Because conflict could be many issues. And then to follow what the state's argument was this is more specific.
I'm not sure if they addressed competency itself. I do know there was discussion about disagreements with continuances and communication issues.
And the continuances relate to the competency request.
I think just the objection to the continuances that occurred kind of in conjunction with the speedy trial issues that the case was being continued. And I'm not sure if there was, he also, in this case, is arguing that he was prejudiced by the 23 days that it took delaying his trial for the competency finding, and that Mr. Collins doesn't believe that trial counsel had any facts to support his request or hadn't done a very limited investigation to support his request. And there's no questions, I'll submit the case.
All right, counsel, thank you very much for your briefs and your arguments. We'll get an opinion out to you soon. And with that, court is in recess until 9 o'clock tomorrow morning.
All right. We're not here, but. I'll leave this. But there's this weird question.